Good day, Crime Talk aficionados. My name is Scott Reisch. Thanks for watching Crime Talk. First on the docket, the Lorivalo Chad Daybell matters. As we all know, Lorivalo appeared for her arraignment last week, and now the matters are set. Now, let's take a look. If you take a look at Lorivalo's trial setting order, her trial is scheduled to commence on March 22nd, and then it goes through the 26th, resumes again on the 29th, 30th, for a total of 10 days. If you take a look at the order for Chad Daybell's trial, you see that the trial schedule begins on January 11th, 2021, and continues through January 29th, 2021. That is some 13 days. Obviously, the district attorney thinks that if these matters are separate, that they won't need as much time. First trial always takes a little bit longer, but by the second time, it will in fact go much smoother because you know what the witnesses are going to say. They know what they're going to say. The witnesses aren't that intimidated about going to court. And frankly, you've had a dry run at it. Now, this issue still remains, will there be a motion for joinder granted where a joint trial will be held with both Lorivalo and Chad Daybell? And I told you last week, the reason for not having a joint trial for these two, cited by Mark Pryor, Chad Daybell's attorney, is founded nowhere in law whatsoever, although he can say, well, it's going to be more press if there's one trial versus two. I think there's going to be plenty of press whether there's one trial or two. The reality of it is that he cited no reason not to have a joint trial. He may be hard-pressed, but we shall see, because also what is interesting in the court orders for both Chad Daybell and Lorivalo is that all of their motions are due 28 days from the date of arraignment. So what does that mean? We know that based upon the date of arraignment, Chad Daybell's motions should be due about September 21st. And since we know Lorivalo's date was just last week, her pretrial motions are going to be due roughly about October 8th. Why is that significant? That is truly going to show us what evidence the defense doesn't think should come in, whether it was obtained illegally. It's irrelevant. There's going to be pretrial motions to try and keep that evidence out. It's going to let us know, as the observing public, what is their true trial strategy. Is it Alex Cox is the one that did it, and we had no idea, and oh my gosh, we were duped by Alex Cox? I think that's kind of my leading theory that I would go on as someone who's practiced law for some 25 years. Never hurts when you can blame the dead guy. Why? Because dead guys don't talk back and cannot profess their innocence. Don't see each other pointing the fingers at each other as long as you've got somebody that can say Alex did it, or at least raise the inference that Alex did it. Remember, ladies and gentlemen, the defense does not have to prove their client's innocence. The prosecution always bears that burden to prove each and every element of the offenses charged beyond a reasonable doubt unanimously to a jury of 12 people. The defense is going to be able to argue any reasonable inferences drawn from the evidence or lack thereof. And guess what? A lot of stuff with Alex Cox. And guess what? Alex Cox won't be there to defend himself. Expect that to be flushed out when it comes to the motions hearing. And that's when things are really going to get good. Next on the docket, a Brianna Taylor update. For those of you who are not familiar with the Brianna Taylor case, she was killed in her Louisville, Kentucky home when police officers were executing a no-knock search warrant at her residence. This was based upon some stale information about an ex-boyfriend who may have been receiving some drugs at the house. Needless to say, the police went in. They say they announced their presence. The boyfriend of Brianna Taylor also has a right to defend himself in that home, not knowing necessarily if it was police, particularly if the police didn't announce themselves, even though they said they did. It's kind of a question of fact. But ultimately, the boyfriend fires back. At that point, the police officers open fire, sending off many, many rounds, ultimately killing Brianna Taylor. No charges have been filed against the police. The matter will be going before the grand jury. But in lots of cases like this, there is stall and delay, and they hope it goes away. Well, now the city, and according to press releases, at about 2 p.m. this afternoon, the city is expected to announce that they have come to a settlement, and it is estimated to be about $12 million to the Brianna Taylor family to resolve their legal claims against the city. Certainly, that will not bring Miss Taylor back, but hopefully it helps the family in some way. Certainly, they would rather have Miss Taylor there than the money, but that's the reality of the civil process. It is to try to make people whole again. Sometimes you can't, so the only way to do that is writing big checks. And if you may recall, I said early on, not sure if the police are going to be charged in this particular case because once the boyfriend opened fire, they thought their lives were in danger, so they opened fire. And based upon their training, they keep firing until basically somebody else stops shooting at them or all their bullets are gone. So I did say the city better get their checkbook ready, and guess what? They're getting out the checkbook. One of these days, you think citizens around the country would get tired of paying these kinds of settlements to families that could have been avoided if there was just a little better police work going on. Here, there's evidence that the information was stale as it related to the search warrant, as the boyfriend wasn't there, and obviously they found no drugs. Unfortunate situation for sure. Next on the docket, Lorivalo wants a joint trial. Only problem for her may be that her husband doesn't want a joint trial. As you may recall, ladies and gentlemen, the prosecution has filed a motion for joinder. We've talked about this over the last several weeks and what it in fact really means. And late last night, guess what appears on the court filings? That's right, a notice of non-objection regarding motion for joinder. Lorivalo, through her attorney, filed a simple motion, and it said that comes now the defendant, Lorivalo, and provides notice that she does not object to the motion for joinder filed by the plaintiff on or about September 1st, 2020. That's the motion filed by the district attorney. Now, you may recall her husband objected to the motion for joinder. So this is going to be interesting. I think we have the inconsistent theory of defenses already coming about. Now, we talked about this a little bit last night on our live program, and if you missed it, you can go back and watch the video. But let me give you it in a nutshell. If there's going to be a joint trial, one of the ways to not have a joint trial is to say that you're going to point fingers at each other. I personally think that Mr. Means, Lorivalo's attorney, is not that good. Mr. Pryor, Chad Daybell's attorney, is good. I think Mr. Means wants to be there to simply say, me too. Yep, whatever Mr. Pryor said, me too on behalf of my client. I also believe that Mr. Pryor, on behalf of his client, Chad Daybell, wants to take a theory of defense of what is commonly referred to as in the criminal defense area as the Sergeant Schultz defense. I know nothing. I don't know how those children's remains got there. I had no idea what this woman and her brother Eric were up to, and that simply you can't convict me because I had no idea what they did. You can't very well do that if you got the co-defendant sitting next to you. That is why the motion for an objection to the joinder has been filed by Chad Daybell, and I believe that that will be supplemented, and I think it will be clear that they have inconsistent theories of defenses. So we shall see how this plays out. Wouldn't you love to see them at the table themselves, seeing how they interact at the defense table during the trial? Now, and on one other note, it appears as though the jury trial date has been changed for Lorivalo. Her jury trial is set to take place now between March 22nd and April 2nd. It's unclear what exactly was the basis for this to take place, but that's fine, and I think it may not even matter if there is, in fact, a joint trial. We'll have to wait and see. There's been all kinds of surprises in this case, and literally every day, just when you think there's nothing to talk about, bam, somebody files something, and there you go. Now, next on the docket, we have seen this question many, many times in the comment section, as well as our live conversations that we've had with individuals, whether it's in our Patreon group or when we just go live on Tuesday nights. And that question is why are Chad and Lori not charged with murder? For God's sakes, they found the bodies of JJ and Tylee on the property. How much more do they need? Well, ladies and gentlemen, I'm here to explain it to you. In every criminal case, you have to have, and this is real simple criminal law 101 from your first year law school. You have to have an act with a guilty mind. So you have to have what they call actus rea, and I assure you, nobody uses that term except when you're in law school. And then you have mens rea, which is your mindset that the prosecution has to prove. Now, let's take a look real quickly here at count 1 in Chad DeBell's case. It's destruction, alteration, or concealment of evidence. And it's alleged very quickly that the defendant, Chad Guy DeBell, on or about the 22nd day of September 2019 and the 9th day of June 2020 in the county of Fremont, state of Idaho, did willfully conceal and or did aid and abet another to willfully conceal human remains, knowing that some human remains were about to be produced, used, and or discovered as evidence in a felony proceeding, inquiry, and or investigation by law, with the intent to prevent it from being so produced, used, and or discovered. So there's a couple of key words here, all right, in these charging documents. First, the word willfully, all right? Willfully. What does willfully mean? So willfully is the mental state. There are several mental states that an individual can be charged with in any criminal complaint. The first is intentionally, and that's when a defendant desires that his acts cause certain consequences or knows that his acts are substantially certain to produce those consequences. Then you have knowingly. A person acts knowingly when he knows the nature and or result of his conduct. A lack of knowledge can often excuse criminal liability under the defense of mistake of fact. Traditionally, intent has been defined to include knowledge. That's key, ladies and gentlemen. And a person acts purposefully when there exists a conscious objective to engage in such conduct or to cause such a result. And willfully is defined as encompassing the concept of intentionally and purposefully, as opposed to accidentally or negligently. And that's been used to imply like an evil purpose in crimes involving moral turpitude. The bottom line, what this means is that you have to prove not only that the remains were concealed there, you have to prove that Chad DeBell and Lorivalo willfully concealed or aid and abet another to willfully conceal, knowing that those said remains were about to be produced, used, and or discovered as evidence in a felony proceeding. But it comes down to knowledge. So a lot of people ask, Scott, they found these remains on the property. Why is it they're not charged with murder? Well, they have to prove first who, in fact, harmed these children. It's not a gut instinct. It's not a suspicion. It has to involve evidence, usually an eyewitness or an admission. And that admission has to be corroborated by the physical evidence. We don't have people just confess, but there's no evidence to support that particular admission. That's why prosecutors are always looking for items to corroborate pieces of evidence or story, parts of the story from a defendant to corroborate, say that's true. It's not a false confession in any way. So you have to be able to show knowledge. Think about it. Let me give you a quick example. Who here has children? Raise hands, right? Do you ever let them borrow your car? Think about it. You say, hey, behave yourself, borrow the car, but be safe. Don't let anyone do anything stupid in it, right? So you drive the car after your child has driven the car. You don't know who was in the car with your children, but you take your kids at their word that there's nothing that you should be worried about. You get in the car, you get pulled over for speeding, and for some reason, the officer thinks that maybe you're being a little suspicious and asks, hey, would you mind if my dog back here, my drug dog, would, maybe search around your car a little bit? And if you, of course, not knowing or exercising your rights, say, absolutely not. I have a Fourth Amendment right. No, thank you. But the cop says, doesn't matter. Don't need that anyway. So he just walks the car around. The drug dog then says, there's drugs in the car. You say, sure, open it up. I have no idea what you're talking about. They find drugs in the back seat, stuffed in the back seat. Are you guilty just because the drugs are there in your car? You would probably say, no, you didn't know about it. Well, that's what the prosecutor would have to prove if they wanted that case to go to trial. There was, potentially the act of possession of drugs in our example, but there's no way that they can prove the mens rea, that one knowingly or even willfully tried to possess those drugs. Therefore, hopefully that case would not be filed in any way, because just because the drugs are in the car, they still have to prove that you knowingly possessed it. Similar to the crime that Chad and Lori DeBell are charged with. They have to prove that they knew the bodies were there, which is why I've said Chad DeBell is going to take the Sergeant Schultz approach of, I know nothing. And for those of you who aren't old enough to understand the Sergeant Schultz quote, I guess you'll have to look it up, or maybe Frank can find a clip of Sergeant Schultz. We'll see what he can do.
Oh, I see nothing. I was not here. I did not even get up this morning.
So hopefully that answers the question of why can't they be charged with murder? The remains were found in their property, for God's sake. You have to prove you knew they were there, and you have to prove the act plus the mental state. Otherwise, no crime. Yesterday on the docket, we had a lot of response as to why someone can't be charged when they find remains of somebody on their house. Why can't they be charged with a homicide? We found a case that illustrates the difference between the Lorivalo case and this particular case. So let's take a look at Lori Shaver. She's been detained for the death of her 35-year-old husband, Michael Shaver, who has been missing since 2015. Now, Michael worked at Disney World as a monorail mechanic, and he vanished in 2015, but he wasn't actually reported missing until 2018 when a suspicious friend who had not heard from him requested a welfare check. When officers arrived at the couple's home in Florida in early 2018, they found no sign of Michael whatsoever. Now, Lori told the police, allegedly, that she hadn't seen from Michael since 2015. She permitted her home to be searched, but eventually referred police to her attorney for any further questions. Michael's last sighting was actually November 7th of 2015. Now, the probable cause affidavit reports that between 2015 and 2018, Lori allegedly pretended to be Michael on social media, assuring his family and friends he was fine, just having started a new life in Georgia, and he just wanted to be left alone. Police further allege that Lori signed into Michael's social media account in January of 2018, 2 months before his body was actually found. The police also alleged that Lori had drained her husband's bank account during his disappearance. She also sold off his tools and firearms, I guess figuring he wasn't going to need them. Well, his remains were found in March of 2018 by a cadaver dog searching the couple's 5-acre property. The body had been buried beneath a concrete slab on top of which a fire pit had been installed. Does any of this sound familiar to a couple of the cases we've been following here in Crime Talk? Michael's body was positively identified through DNA in roughly June of 2018. What happened to Lori, which led to her demise, is she started dating a few months after Michael's death and told her new boyfriend he was not missing. In fact, she told him he was no longer walking this earth. The new then boyfriend, a gentleman by the name of Travis Filmer, cooperated with investigators. Filmer also allegedly told them that she had admitted to burying her husband's remains on the property. Lori is also charged with being an accessory after the fact to second-degree homicide, and she's currently being held in jail without a bond. Police still don't really have a motive other than she just didn't want to be with Michael any further. There was apparently a domestic dispute in 2014 where Lori allegedly struck Michael with a gun, but he was the one that was actually arrested, as officers believed he was the one who pulled out the weapon during the fight in the first place. Investigators also believe that Lori told friends and family that Michael had been stalking her and that she was receiving child support payments from him. Despite never filing divorce papers, Lori eventually remarried in a ceremony that was allegedly conducted near the concrete plot where Michael's body was buried. To add insult to injury, investigators say that the new couple's initials were actually etched into the concrete above the exact spot where Michael's body was found. That's cold. Now, the moral of this story is that, as you can see, just because a body is found in your backyard doesn't necessarily mean that the police can prove that you had something to do with it. It was not until the ex-boyfriend came forward and stated that Lori had in fact told him that Michael was no longer walking the earth and that she had disposed of him. The moral of this story is that you can see, just because a body is found on your property, as it was in this particular case way back in January of 2018, it doesn't necessarily mean that the police can charge you with something unless they have some information which talks about knowledge, that knowing element. Here, the ex-boyfriend of Lori came forward and stated that she had said he's no longer walking the earth, as well as the fact that she admitted to burying his remains. That is enough to do that. As you can see in the Lorivalo Chad DeBell case, there's no admissions, at least a direct admission where somebody says they buried the remains or they had something to do with the death. But you saw what the police did in this particular case in Florida as it related to Lori Shaver. They waited. He's reported missing in 2018. They find the body in 2018, and now they're just finally getting around to it so that they made sure that they had enough information. If they had simply charged her with possibly having the remains in the backyard with no evidence of that, she would either have been found probably not guilty, and jeopardy certainly would have attached under the rule of compulsory joinder, where you have to bring all actions at the same time. You cannot piecemeal them together. Here, the police waited. They got the murder charge as well as the accessory for burying the body in the backyard. Sometimes you just have to be patient. Obviously, we'd always like to have the cases where someone is charged, promptly taken to trial, convicted, and or found innocent. But sometimes you have to be patient. That's why we have lengthy statute of limitations in most cases involving homicide. That's all we've got today. Hope you enjoyed it. Have a great weekend.